Welcome everyone to our webinar on managing employee performance, legal considerations and best practices. My name is Saeidul Haque and I'm a Senior Associate in the Employment and Health and Safety team at LegalVision. Before we begin today, a couple of quick housekeeping items. So we will be recording this session today and you will be emailed a copy of it. So if you miss anything, you will have a chance to look back later. We'll also be taking questions at the end, so please submit your questions in the Q&A box, and I will try and answer as many of them as I can at the end of the session. Finally, there is a survey at the end of this webinar, and I would be very grateful if you could please complete this to give us any feedback. For the next 48 hours, you are also eligible for a free consultation with LegalVision to discuss how we can help your business. To claim this consultation, please provide your contact details in the survey at the end of this webinar. So before we begin, just a quick poll question which should come up on your screen. So which aspect of managing employee performance is most relevant to you? So the answers are overall considerations when managing employee performance, handling performance issues, so informal and formal methods, including performance improvement plans, termination procedures and managing associated risks, or you're not sure and you're just here to learn. So I'll just give you a couple of minutes just to have a think about that and provide your answers. And just to confirm again, that question was, which aspect of managing employee performance is most relevant to you? Is it the first option, which is overall considerations when managing employee performance? The second one, which is handling performance issues, including informal and formal methods. Third option, which is termination procedures and managing associated risks, or you're just not sure and you are here to learn. Okay, brilliant. So looking at the results then, it looks like we've got a bit of a mixed bag. I think it looks like overall consideration of managing employee performance is sort of the main reason you guys are joining me today. So we'll definitely touch on those today. So as you can see on the screen, today we'll be discussing legal considerations, informal ways to manage poor performance, formal ways to manage poor performance, termination for poor performance, and any risks associated with termination for poor performance as well. Again, as I say, at the end of this webinar, I will be answering some of your questions. So please feel free to submit your questions throughout the webinar through the chat function, and I will answer as many as I can at the end. If I don't get to your question, please do leave your contact details in the survey when the webinar ends, and do claim your complimentary legal consultation and book a call with me. So starting with legal considerations today. So the main thing, I guess, is that poor performing employees can be a very difficult situation to manage, especially given that it can be a drain on your internal resources. This can not only affect productivity and team morale, it also poses legal risk if it's not handled correctly. Now, when an employee is underperforming, it is their capability which is called into question. And capability simply refers to an employee's ability to perform their job to the required standard. And this includes by reference to their qualifications, their aptitude, their skills, their health, and any other physical or mental quality that affects job performance. Capability is one of the potentially fair reasons for a dismissal under the Employment Rights Act 1996. Examples of poor performance can include a lack of productivity, inflexibility, or any other failure in an employee's duties. Now, in general, capability issues fall into two main groups. We've got general poor performance, which may be due to a lack or a gap in an employee's skill, knowledge, or aptitude for the role, or it could be poor performance due to ill health. And this includes both physical and mental health ailments, which may affect an employee's ability to perform their role. It is also worth noting that sometimes these categories may overlap, and it's also worth noting that if an employee is able to do their job but chooses not to do it for whatever reason, it might actually be a conduct issue instead. Now, this webinar will mainly focus on general poor performance. While capability is a potential fair reason for dismissal, employers are still obliged to follow a fair procedure to avoid claims of unfair dismissal and or discrimination, where performance issues relate to a long-term condition or a disability. Now, this typically involves identifying the performance issue initially, providing support to the employee and the opportunity for improvement, and following a formal capability procedure if necessary. Throughout the capability process, it is prudent to document the process that is followed, and that includes performance reviews or appraisals, meeting minutes, performance improvement plans or PIPs, and any other relevant correspondence, because these documents will serve as a record in case there is any escalation to an employment tribunal. Now, addressing performance issues early is important to save both time and costs. If concerns are highlighted at an early stage, an employee is more likely to turn their performance around. Allowing the issues to fester can lead to a time-consuming and possibly lengthy process. Before starting any formal process, it is worth often considering informal steps to manage performance, and often an informal discussion can be a less confrontational way of addressing the issues before resorting to your formal procedures. Now, these discussions can help to identify any underlying causes, provide necessary support, and give the employees an opportunity to improve without the stress of a formal process. Now, this informal reminder to an employee of their obligations can also lead to an improvement in their performance, engagement, and also create a more productive workplace environment. The key to an informal approach encompasses a couple of points. The first point is identifying your concerns. So managers should look to conduct a thorough assessment of an employee's performance. You should be able to clearly identify where an employee's performance is falling below your expectations. And as part of this process, evidence of this should be gathered. And this could include statistics, reference to KPIs, or simply by comparison to colleagues. Next, a private meeting should be arranged with the employee to discuss your concerns. And during that meeting, the issues should be clearly communicated to the employee, who should be given an opportunity to set out their perspective and any challenges that they are facing. The employee should be encouraged to be open to allow you to fully understand the reasons for their poor performance. Now, you should also consider adjustments if you have reason to believe there may be other matters influencing an employee's performance, such as a medical condition or issues in their personal life. It is important to approach this with sensitivity and consider how this may be impacting the employee's performance. Now, if the employee discloses a medical condition to you that affects the way they work, you are legally obliged to consider putting in place reasonable adjustments. And these are effectively just changes to the working environment or your practices that help the employee to perform their role effectively despite their condition or ailment. Adjustments can include modifying work schedules, altering the physical workspace, providing specialized equipment, or redistributing certain tasks, or it could be as simple as just giving the employee additional time. You should work collaboratively with the employee to identify suitable adjustments that will enable them to meet your performance standards while accommodating their needs. You should remember that this applies to both physical and mental health conditions as well. You should agree jointly with the employee a set of specific achievable goals to address the performance issues, and this is commonly referred to as a PIP or a performance improvement plan. Now, if you identify that the employee needs further training or support, this should be put in place as soon as possible. Ultimately, the employee should clearly understand what is expected of them in the foreseeable future, and these goals should be reasonable. If you set unachievable goals or you don't put in place any support measures, you could actually be setting up the employee for failure. You should also look to set timescales and review methods. So a specific time frame should be given to the employee to improve their performance. And generally speaking, 3 to 6 months can be considered a reasonable period of time for improvement. However, there's no sort of hard and fast rule about this. There's no specified period of time that this has to be. Ultimately, the time given to an employee will depend on your circumstances, your concerns, your custom and practice, or any written policy that you have internally as well. In terms of reviewing an employee's progress, it would be wise to have regular check-ins with them, and this could be on a weekly, fortnightly, or monthly basis, depending on the amount of time you've given the employee to improve their performance. You should also look to provide necessary support depending on how the informal meeting with the employee goes. So that could be additional training or just general support. So, for example, if you identify that employee is clearly struggling with time management, you may wish to train the employee on different methods they can utilize to manage their time more efficiently. The employee should also not wait to raise any concerns with you before any sort of review meeting. They should be encouraged to reach out to you for any questions or any concerns throughout the informal process on an ongoing basis. It is also important to document the process. So any meetings held with the employee should be minuted in the event you need to rely upon it in the future as a record. Equally, the plan and method of review with the employee should be documented in writing and shared with the employee as well. You should also consider issuing a letter of concern to the employee, expressing your concerns and enclosing the agreed plan to address their performance issues. And the employee should be clearly told about the potential consequences if their performance does not improve to your required standards. You should also follow up and monitor the progress. So you should stick to the agreed review schedule and provide feedback to the employee on their progress. There is simply no use in putting in place a plan if you don't follow it. If the employee's performance does improve, then this should be clearly communicated to them. If, however, issues do persist, you should consider reminding the employee of the objectives or adjusting the plan based on the circumstances and their progress. If you happen to identify any new performance issues during this process, these issues should be addressed promptly in the same manner. Now, if the employee's performance improves to your required standard, you should communicate this to the employee, but highlight that you will monitor the situation and sort of provide support as necessary. If, however, an employee's performance does not improve to your required standards, you should consider formally escalating this matter. Now, if an informal approach to the management of the performance does not lead to your desired improvement, it may become necessary to commence your formal procedures. And the transition from an informal to a formal process can be seen as quite a significant shift and introduce a more structured and documented procedure. While this may initially be more stressful for the employee, it is important to address the ongoing concerns with a clear framework for improvement, and the following steps are important to consider when commencing a formal procedure. So the informal steps taken initially before the formal procedure can serve as a preliminary investigation into the employee's performance issues, and where possible, the formal process should be overseen by someone who is not involved in the initial stages. This would be important in the case the fairness of the procedure is challenged by an employee or if they make any accusation of bias. Again, this is another reason it is important to document the initial stages. The employee should also be clearly informed when you are transitioning from your informal procedure to your formal procedure. And the way you do that is with an invitation letter, which should be prepared and sent to the employee in good time, which should be at least sort of 48 hours before the hearing, or as otherwise set in your policies or employment contracts. And that invitation letter would be for a formal capability hearing. Now, this letter should include a variety of different things, including details of the performance issues, which may just be a reminder of them, given that they would have been initially aware, the date, time, and location of the hearing itself, details of the evidence you intend to rely upon, along with copies for the employee to review ahead of the hearing, an outline of the procedure that you will be following, and forewarning the employee of the potential outcome to the formal hearing. And you should also set out the employee's right to be accompanied by a fellow employee or a trade union representative if one is recognized in your business. Now, conducting the formal hearing will be quite similar to the informal process in that you should express the concerns you have to date and any action the employer has taken to remedy this, equally any action you've taken to address them as well. If you have evidence that you're relying upon, this should be presented to the employee with a clear explanation of how this supports your position, i.e., if there's clear stats showing that the employee's not performing to the required levels compared to colleagues, they should be clearly communicated to the employee. You should explain your concerns that you still have and allow the employee again the opportunity to respond and provide their perspective. And the main purpose behind this hearing will be to obtain the employee's commitment to improvement. The potential outcome to this process can range from a verbal warning to a dismissal for poor performance. And typically, you will be expected to start from a verbal warning and then increase the level of warning if you have to go through the formal process again. This would, however, depend on whether the employee has any previous warnings for poor performance that are still live or the severity of the offence committed by the employee. The outcome should be delivered to the employee in writing in any event, and they should be given the opportunity to appeal that decision. Now, as with the informal process, it is important to document the discussion that takes place with a view to monitoring and perhaps reviewing the employee's progress against a set of achievable objectives. Now, if an employee's performance still continues to fall below your expectations, you can consider having subsequent formal hearings with a view to escalating the warnings, such as moving from a verbal warning to a written warning or from a written warning to a final written warning instead. Now, when your formal process has been exhausted, you may need to consider terminate your employment relationship with the employee for poor performance. This should be really a last resort option after you've exhausted your informal and formal procedures. And some factors sort of consider include consistency. So before sort of taking the decision to dismiss an employee, you should ensure that you have invoked and use your formal process consistently. Because if you had a situation, for example, where an employee with a protected characteristic, such as a disability, is found to be treated differently to someone without such a characteristic, it could lead to allegations of discrimination or perhaps even a claim at the employment tribunal. There is also no absolute obligation for you to consider alternative roles before dismissals, but it can go some way to help reduce the risk of a claim being brought by an employee, particularly if you work in a large organization. In essence, this usually involves a demotion, such as a move from a senior position to a more junior one instead. So from, for example, a senior associate role to a junior associate role instead. So, usually performance issues occur after an employee's performance levels rather drop after a promotion. So it could be a demotion, perhaps back to the role they're in previously. But whether or not you must consider alternative employment is down to your resources and the background to the situation, and perhaps an employee's employment tribunal's interpretation if a dispute does arise. Now, termination should be considered when all other alternatives have been exhausted and if the performance still remains unsatisfactory, because then it may just simply be unavoidable. Now, this decision should not be taken lightly and must be handled with the utmost of care, because if termination is deemed necessary, it is important to arrange a meeting with the employee to communicate that decision clearly and empathetically as well. This should be followed by a formal termination letter that outlines the reasons for dismissal, that references the performance management process undertaken, and provides essential details such as the effective date of termination and final payment information. The letter must also clearly state the employee's right to appeal the decision, including how and when to submit an appeal. Now, if an appeal is lodged, it should ideally be heard by a senior manager not previously involved in the case, and the final decision should be communicated in writing, and that would be the final right of appeal for the employee as well. Now, throughout this process, you should adhere to company policies and contractual terms to ensure fairness and to mitigate the risk of any potential legal challenges, because the proper handling of termination not only protects your organization legally, but it can also help to maintain your reputation as a fair employer. Ultimately, before you commence any formal process or take the decision to dismiss an employee, it would be wise to seek legal advice to discuss the merits of the case and to identify any associated risks. Now, the main risks associated with a dismissal for poor performance include unfair dismissal, which is the primary risk, I would say, associated when terminating employees' employment for poor performance, and that would be for ordinary unfair dismissal. An employee may be eligible to bring such a claim if they have at least 2 complete years of service with you. For employees with less than 2 years of service, they would not be able to bring a claim for ordinary unfair dismissal. However, they may be able to bring other types of claims that do not have prerequisite lengths of service, for example, discrimination or contractual claims. It is equally worth noting as well, with the recent change in government from Conservative to Labour, there is the Employment Right Bill that is passing through Parliament at the moment. And one of the plans is to allow employees to bring a claim of unfair dismissal from the very first day that they're employed. But that's just something to bear in mind. It's not been put in place at the moment, but it is something that is worth noting. Now, while strictly speaking, a poor performance, or more specifically capability, is a defense to an unfair dismissal claim, often employers will make a mistake during the formal process, which can render the dismissal as being procedurally unfair, even though the reason for it might be fair. So failure to carry out a fair and reasonable process could lead to a finding of unfair dismissal. So it's important that you document each stage of the process carefully to demonstrate fairness if you are challenged by an employee or if a claim is brought. The next sort of main risk is that of discrimination, because what you should do is ensure your capability process rather does not directly or indirectly discriminate against any sort of employee on the basis of a protected characteristic such as age, disability, or pregnancy or maternity status. So employers are legally obliged to make reasonable adjustments for disabled employees to help them overcome workplace disadvantages, and that could include modifying, the work schedules, the working environment, specialized equipment, or reallocating certain duties. Ultimately, what constitute a reasonable adjustment will depend on factors such as the size and administrative resources available to you as a business, as well as the practicality of the adjustments as well. That helps the effectiveness too. Excuse me. Now, when considering adjustments, you should engage in open dialogue with the employee about their needs. In some cases, that could include obtaining a medical report, of course, with the employee's consent, because that can provide valuable insight into the condition or conditions that may impact on their work and help inform you about appropriate adjustments. A failure to make reasonable adjustments when required could lead to claims of discrimination. Moreover, if poor performance is linked to a disability and this isn't appropriately considered during the capability process, any subsequent dismissal could be deemed to be discriminatory. In summary, while managing poor performance, you should carefully consider whether any protected characteristics are relevant to the performance issues. You should make necessary reasonable adjustments and ensure the capability process itself doesn't disadvantage any particular group of employees, such as those with disability or perhaps those who are pregnant or off on maternity leave as well. Now that concludes the main part of our webinar today, but you might find our publication on how to hire and inspire in the UK quite useful, and it is available for free download on our website, which you can do by scanning the QR code or, as I say, by visiting our website. We also have an upcoming webinar that may be of interest to you, which is on protecting your business, there's sort of most valuable assets. So that's your IP. And that's on next Tuesday, 24th of June at 11 a.m. BST. And you can register for that at the link shown on the screen. I'll give you a couple of minutes just in case you want to click on that one. Now, we're going to answer your questions shortly, but while you do submit them, we'll take a minute just to tell you a little bit about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100 plus specialist lawyers for all your business as usual legals needs. It's ultimately like having your own in-house counsel for a fraction of the cost. Our team can assist you with a variety of different things, such as unlimited document drafting and a review of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registrations, and much, much more. It also includes advice on matters such as HR, issues such as managing an employee's performance or capability, or conduct or any sort of other day-to-day issues that may arise during the course of an employment relationship. Now, as a LegalVision member, you wouldn't need to worry about the cost of lawyers ever again. Think of it as having your own in-house legal counsel, because what we'll do is take care of your sort of business as usual legal needs, and you can focus on running the business. And if you are in-house legal counsel, we do offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about our membership and or about how our desk extension product can be of assistance to you, you can request a free consultation when the survey appears at the end of today's webinar. And now we'll look to answer some of your questions because I can see a couple of them have popped through. If I just bring them up very quickly. One of the questions was about how can I access a recording, join in late? Don't worry about that. What we'll do is send a link to the webinar after this, and it will include a link to the recording as well. Another question we've been asked is how to deal with difficult employees, which is a good question. I mean, ultimately, I would say that the same approach really applies that we outline in today's process and in webinar. Sometimes an employee, it may be not a case of capability, but rather conduct instead, i.e., where someone is actually capable of doing the job, but is choosing not to do that for whatever reason. Now, these types of matters should be addressed through your internal disciplinary process, and that can start with an informal meeting, similar to the capability process as well. And you could start by issuing sort of an improvement notice on the back of an informal meeting, or a letter of concern, setting out your concerns. And if that doesn't address your concerns and you still need to sort of address it formally, then you might want to consider going down your formal sort of conduct process, which is quite similar to a capability process in the sense you have the investigation, you have the formal hearing, and then you have the outcome. And then, of course, you allow the employee to appeal that outcome if they wish to do so instead. Hope that answers the question nicely there. I can see we do have another question that has popped through as well. So that is all about can an employee claim unfair dismissal for poor performance if they have less than 2 years of service? So again, another good question. Simple answer to that is yes, they potentially can, depending on when it happens. Because as I mentioned, the government Labour are planning to change the laws so that employees with less than 2 years of service can potentially bring a claim for unfair dismissal as well. Now, that's more sort of in the future. At the moment, they can't technically bring a claim for ordinary unfair dismissal if they have less than 2 years of service, but it would be recommended that you do seek legal advice because there might be other risks to consider, which may not require 2 years of service, such as discrimination claims or other claims associated with the contract, such as the notice pay, holiday pay, that sort of thing as well. So it's always important to make sure you do seek that advice before taking that decision to dismiss an employee. We've had another couple of questions pop through as well. So we've had a question that says, what if we don't have different people to deal with different aspects of the formal capability process? Again, another great question because typically businesses in the UK are quite small businesses by and large. The most of them are small businesses, and typically be sort of a one-man operation, or it'd be a very small leadership team within that organization. So where you don't have different people to deal with different aspects, and where that's not possible, that's completely fine. You can only do with the administrative resources that you have in place at the time. So, if an employee raises it as an issue, we would just try and flag to them, at the end of the day, we don't have the resources to allow different people to deal with it, and therefore we'll sort of look to keep it internally. Another option could be to consider external support, whereby you could get, external HR support and get an external HR consultant or a solicitor to oversee that process on your behalf. That way, a third party is dealing with it. But of course, with small businesses, you do have to think about your administrative resources, including sort of financial resources, which may not be there. And ultimately, it's not something you really have to consider anyway if you don't want to do so, particularly if you don't have the financial resources. So I hope that answers your question there nicely. I think we do have time for some more questions. I've got another one here about what is considered a reasonable time to give an employee to improve. So, a reasonable time really again depends on your business, any sort of previous custom and practice, any sort of internal policies. Typically, I would say on a general basis, you'd be expected to give an employee at least 3 to 6 months to improve. Of course, someone's in their probation period, you might want to consider giving them less amount of time. Or if you've gone through the process before in the past, again, you might want to give them less amount of time to improve. But ultimately, the objectives you set perhaps going to be more important because they should be achievable and measurable by you on an objective basis as well. Because if they're not, you're ultimately setting the employee up for failure. I'll just see if that's all the questions because I believe it is. It is indeed. So that's all the questions that we've answered today, and that's all we have time for today as well. But after the webinar ends, a survey will pop up, and we would be really appreciative if you could complete the survey at the end. Please also remember that you can include your contact details to receive a complimentary legal consultation to discuss how we can help you with your employment contracts, key clauses, as well as any other sort of HR matters as well. But otherwise, that ends today's webinar. Thank you very much for joining us today. Take care.